Greetings and welcome to episode 4 of the Politics of Prosecution video series. In this episode, we get to finally look at the prosecutors themselves. In our first episode, we had an introduction to the Politics of Prosecution. Episode 2 looked at the government structure. Episode 3 looked at the criminal court process. And now we finally look at the prosecutor's role in that process. And to do so, we're going to look at 3 key topics. We're going to look at whom do prosecutors represent. We're going to look at how they exercise something called prosecutorial discretion. And then we're going to look and see how prosecutors obtained the power that they have in today's court system. So our first question that we need to address is, whom do prosecutors represent? Prosecutors are attorneys. They have clients. But unlike regular attorneys who represent particular individuals or particular corporations, prosecutors represent a multitude of different possibilities. It could represent anything from the government to crime victims to police to a community. That ambiguity regarding their potential client creates difficulties for prosecutors when they exercise their decision-making authority. The first thing we need to do when we're looking at the question of whom do prosecutors represent is we need to distinguish between federal and state prosecutors. Federal and state prosecutors work and behave differently. If you recall from episode 2, we introduced the idea of federalism, the difference between the national government and the state governments, and we said that both are sovereign. Both the federal government and the state governments can prosecute violations of criminal law, and they have different prosecutors to do that. The federal prosecutors are called United States attorneys. Those who assist the United States attorney are assistant United States attorneys. They date back to the Judiciary Act of 1789 when the United States Constitution first got underway. The very first Congress created the position of United States Attorney. Today, they are codified in the United States Code in Title 28, Section 547. This statute identifies the responsibilities that federal prosecutors have. Among those responsibilities, as they're broadly worded, among those responsibilities is that they are to prosecute for all offenses against the United States. Basically what that means is they are to prosecute any violation of federal criminal law. And that's all it says. It doesn't give any more detail about how federal prosecutors should handle their decision making. Which cases do they prosecute? Which offenders do they target? What sentences do they recommend? None of that is addressed in this particular statutory authorization. Instead, the statute leaves things very broad, very open-ended for the federal prosecutors to fill in the blanks. Now, contrast that with the different states. The first thing we have to realize is that where the federal government, everyone goes by the same name. They're the United States Attorney, they're an Assistant United States Attorney. The state governments have all kinds of different names and different labels that attach to their prosecutors. In some states, it's the state's attorney. In other places, it's the Commonwealth attorney. Some places simply use the term prosecuting attorney. Others use the term district attorney. There are even some places where they use the term circuit attorney. It all depends on where the jurisdiction is located and what that particular state uses. They don't signify anything different, but it can also be rather confusing for someone on the outside looking in to try and figure out who that person is and what title they go by. All of them have the same basic responsibilities. One of those responsibilities, of course, is to prosecute violations of state law. Whom do they represent, or how do you represent the state. What is a state's interest in a criminal case? Well, historically, as we'll see towards the end of this video, the state had no interest in the case. It was purely the victim who was driving the case. In that particular instance, the prosecutor represented the victim's position in the case. As things went along, you'll find that perhaps prosecutors represented the political party that they were affiliated with, and that the party's interest drove the decision making. In other instances, the prosecutor may perceive themselves as representing the police. The police are the ones who collect all of the evidence. The police are the ones who make the arrests. And so the prosecutor works closely with the police to build the case. And so they may say, look, I represent the interests of the police department. Now, that also falls short because there are plenty of times where the police interests and the prosecutor interests diverge. And the prosecutor has to decide if they're going to follow along the police interests or are they going to pursue the prosecutorial interests at issue in the particular case. The same thing with that applies to the victim. If the prosecutor perceives themselves as representing the victim, then there are going to be times where the victim's interests and perhaps the prosecutor's interests diverge. Prosecutors may also represent a given community. The community has elected that person to that particular office, and so they perceive a mandate to carry out whatever promises they made during the campaign, and that may lead them to represent the community. But at the same time, there are community interests at stake that may diverge from what the state interest or the prosecutor believes is the best course of action, and so the prosecutor may have to go in a different direction. Finally, there is simply the notion that they represent the government, and the government has particular interests. This is sort of the United States Attorney position on the federal level. When they stand up in court, they will say that they represent the government of the United States of America. Now, state prosecutors will not often say that they represent the government of the state of Missouri, for example. They may say they represent the people of the state of Missouri, or they simply represent the state of Missouri. And so there's different phrasings that can lead to slightly different meanings in terms of who the prosecutor represents. And we don't have a clear answer as to whom the prosecutor represents. The closest thing that we get is a United States Supreme Court opinion from the 1930s. The case is called Berger versus United States. In that particular case, there was a question about misconduct committed by the prosecutor during the course of the trial, and Justice Sutherland of the United States Supreme Court had this to say about federal prosecutors. The United States Attorney is the representative not of an ordinary party to a controversy, but of a sovereignty whose obligation to govern impartially is as compelling as its obligation to govern at all, and whose interest, therefore, in a criminal prosecution is not that it shall win a case, but that justice shall be done. As such, the prosecutor is in a peculiar and very definite sense the servant of the law, the twofold aim of which is that guilt shall not escape or innocence suffer. And this has become sort of the baseline understanding of the prosecutor function in the United States. It has transformed them into quasi-judicial roles where they are perceived as ministers of justice, and it is their job, above all else, to ensure that justice is done in each and every case that they prosecute. Of course, the trick is figuring out what justice is, because what is just to one person may not be perceived as just to another. That brings us to this question of prosecutorial discretion. Prosecutors have the ability to decide many different things throughout the course of any given criminal case, and over time that discretion has both expanded and they have become less accountable to others in the criminal court system and others in the larger community. As we talk about prosecutorial discretion, we're going to look at 3 different topics. We're going to look at what is it, we're going to look at where in the process does it occur, and then finally we'll turn to how do prosecutors use that discretion. When we say discretion, what is it that we mean? What do we mean that prosecutors have discretion? It basically means they have the choice to decide what they want to do. They can go one way or the other. Why do they have this? Well, it is not desirable or even possible for prosecutors to prosecute every single violation of every single law. Just on the federal system alone, there are tens of thousands of criminal offenses. Again, one person has said the average person will commit 3 federal felonies in the course of any given day. There's no way that we could prosecute every single violation. And so prosecutors have to pick and choose. They have to decide which cases are worth pursuing and which cases are best left unaddressed. Importantly, when prosecutors are making this decision, there are very few, if any, checks and balances on the process. The prosecutor's decisions generally are not reviewed by anybody. They occur outside of public view. The judge has so many cases, they usually just give it a cursory review. The defense attorney is the closest thing that we have to a check on the process, but they're also overwhelmed with cases that they have to address and can't dig into the details of every single case. And so really the prosecutor is the one who is providing the most scrutiny to any given case. So that raises the question of how should prosecutors use this power? And this is something that is much contested in our society. Some think prosecutors should use it more, some think they should use it less, some think they should use it to target particular offenses, others think they should use this discretion not to prosecute particular violations of law at all. Now, where does this occur in the court process? There are several key steps where prosecutors have discretion. The first is their charging power, and this is the most important. As criminologist Malcolm Feely once said, the process is the punishment. By simply subjecting somebody to the criminal court process, you are subjecting them to punishment, and prosecutors are the gatekeepers to this particular process. They decide what cases will go into court, what cases will be prosecuted, and what cases will not. And there is no accountability for this decision on a day-to-day basis. Prosecutors can refuse to prosecute cases for whatever reason they want to. As long as they have probable cause that the person they want to charge committed the offense, they can go ahead and file the criminal charges. Within this charging decision are several smaller questions that prosecutors must think about and over which they have discretion. The first is, are charges warranted? Is this case worthwhile? Do we at least have probable cause? Ideally, we have proof beyond a reasonable doubt. If we don't have probable cause, we can't file the charges. But beyond that, perhaps this is a very minor violation of law. Perhaps our witnesses aren't very credible. In those instances, we have probable cause, but we may not be able to get a conviction, so let's not waste our time and energy on this case. Let's simply not prosecute. They also can decide against whom they want to bring criminal charges. They may decide that certain categories of people are more important to prosecute than others. We see this in some jurisdictions where they argue that the top 1% of the criminal offenders are committing a large majority of the crimes in that community, and therefore they're going to target that top 1% of the criminal population. Other places are going to strictly enforce particular laws at particular times and say we are going to prosecute all violators of this particular offense. And that goes along with what crimes are we going to prosecute. We may prioritize certain crimes over others. Now we're seeing prosecutors coming into office who are saying we are not going to prosecute marijuana cases. We are not going to prosecute shoplifting cases if they are less than $1,000 of merchandise. Right? Those cases just are not worthy for prosecution in the regular court system because they're so small. Finally, prosecutors can decide when to bring these charges. Most statutes have a statute of limitations, meaning that prosecutions must be initiated prior to the end of that time period, but those time periods are often 3, 5 years, sometimes even longer. And so prosecutors can decide when in that process to bring charges. This is particularly true when we're investigating conspiracies or criminal conspiracies. Prosecutors have to decide when are we going to prosecute in order to break up this conspiracy and stop them from committing any more criminal offenses. Beyond the charging decision, prosecutors also have discretion when it comes to plea negotiations. So once they file charges, the information is given to the defense attorney. Recall our discovery process from the last episode. And now negotiations begin. What is the case worth? What kind of sentence should this person receive? And this is a process of negotiation. This negotiation can take 3 different forms. They can negotiate the charges. So let's say the person is charged with assault first degree. The defense may offer assault third degree as a way of pleading guilty. The prosecutor can accept that or not. We call that charge bargaining, where we are going to plead guilty to something other than what the initial charge was. At the same time, prosecutors can engage in sentence bargaining. This is where the prosecution and defense are going to negotiate over what the sentence is going to be. While the defendant may be charged with assault first degree, the prosecution and defense may debate what kind of sentence that person receives. And so the prosecution may start with a 10-year sentence, the defense may counter with a 2-year sentence, the prosecutor may come back and say 7, the defense come back and say 5, and they settle on 6. Something like that. We call that sentence bargaining. Defendants who are charged with multiple counts. So you may have a case where the defendant is charged with 3 counts of assault first degree. The defense may come to the prosecutor and attempt to count bargain and say, we will plead guilty to the first charge, assault first degree, if you dismiss or not pursue counts 2 and 3. The prosecutor says, yes, that sounds good, and they negotiate based on the counts. All 3 of these can exist on their own, or they can all be used as part of one larger negotiation. Prosecutors can gain some leverage in all of this in a couple of different ways. Number one is they can engage in something called overcharging. So they can look at a case and say, I have probable cause to believe this is assault first degree, but when I get into court, and if I had to prove this beyond a reasonable doubt, I can only really prove assault third degree. Therefore, they may charge it assault first and then negotiate down to assault third, and in reality, they're not giving up anything. This is a way simply to gain leverage over defendants and get them to become more likely to plead guilty. Another thing that may occur is that prosecutors make a sentence offer of, let's say, 5 years on an assault first case. The defense says, no, I want to go to trial. The defendant goes to trial, the defendant is found guilty, and now when it comes to sentencing, the prosecutor says, no, that 5-year deal is, or recommendation is off the table, now it's going to be 10 years. Because you did not save the state resources, you made the state bring in its witnesses and prove its case, that cost a lot more, therefore the sentence needs to go up. In addition, you didn't accept responsibility. You denied that you were responsible for this, but the jury ultimately found that you were, and therefore you're not going to get any benefit from accepting responsibility by entering a guilty plea. Now, conversely, on the other side of that, the defendant is going to look at this and say, wait a minute, would have had 5 years, and now you're saying 10 simply because I exercised my constitutional right to a jury trial. that doesn't seem fair. It's two sides of the same coin, and one thing that this process has been labeled is simply what we call a trial tax. You are being charged more, i.e. getting a longer sentence, for simply going to trial. Prosecutors also have the discretion to dismiss the case entirely. So prosecutors may initiate criminal charges, and as they continue the investigation after initiating charges, they may find new evidence that shows the defendant is actually innocent, or that the defendant may be less culpable than other potential defendants. Or they may find that the defendant comes in and says, if you dismiss my case, I will testify against other people or give you information about other people. In these instances, the prosecutor has the discretion to dismiss the case. No one can force the prosecutor to dismiss the case. Prosecutors simply have that power. Now we move to the third question of prosecutorial discretion, and that is, how do prosecutors decide? How do they actually decide to use this power in any given case? We're going to use the charging decision as our base. That, as I said, is the most important decision that prosecutors make in any given case, the decision whether or not to charge one. And that gives us a full picture of all these different factors that influence prosecutorial decision making. There are two key factors that show up in any given case, and that is the facts of the case on one hand and the attorney who is looking at the case on the other. Those two things are going to come together to decide whether or not a particular case is prosecuted. So let's first look at the case facts. Case facts are by far and away the most important. When attorneys sit down to look at the case, they are going to be assessing the facts, and is this a case that is provable when it gets to a jury. The way they look at this case is a combination of facts and elements. So they look at the elements of the particular offense. What pieces do they have to prove? Remember, we talked about that briefly in the last episode. And they're going to look to see if they have facts that prove each and every one of those elements beyond a reasonable doubt. As they look at the facts, they have to decide what facts are most credible. They may have 3 witnesses to the crime, and each of those witnesses may be telling a different story, and they have to decide which one of those is credible, if any of them. You may have witnesses that have criminal convictions that would make them less credible. You may have witnesses who just are not as articulate as others that may make them appear to be less credible. You may have witnesses who don't recall certain things very well that would make them less credible. And so as a result, prosecutors have to look at credibility of witnesses. They're also going to look at who investigated the case. Not all police departments are the same. Not all police officers are the same. Some do better jobs at investigating cases than others. Some do a better job at collecting evidence than others. And so they're going to look and see how well that particular officer or that particular department handled the particular investigation. They're also going to look at where this crime occurred. There may be high crime neighborhoods where prosecutors are trying to focus their resources. And so if a crime occurs in that neighborhood, they may be more likely to prosecute that case than if it happened in a lower crime neighborhood. They may also look in terms of credibility at the scientific evidence. Is there scientific evidence that demonstrates the defendant committed this crime? Was there DNA found at the rape scene that we can say belongs to our charged defendant? If we don't have that, the chances of prosecuting go way down because jurors expect to have some sort of scientific evidence, especially when it comes to things like sexual assault cases. The problem is when we move to attorneys is that you can have 2 different attorneys look at the same exact set of facts and they can reach 2 different conclusions. One may say that it is an assault 3rd degree. Another one may look at the same set of facts and say this is assault 1st degree. A third attorney may look at the case and say we don't have anything here. What's going to make this difference? What are those factors that are making different people look at the same exact case and reaching different conclusions? Well, we can start with the attorney who is looking at the case. That attorney has a unique set of factors that influence how that attorney perceives the case. The attorney's experience. Someone who has just graduated from law school and looking at their first case is not going to look at the case the same way as someone who has been a prosecutor for 10 years. The person who's just out of law school may miss important issues. The person who has been around for 10 years may pick up on things that the new attorney would not. Conversely, the person who's been around for 10 years may take a very jaded approach at a case, where someone who is brand new may be less skeptical of the motives behind some of the people who are presenting evidence in the case. People have different skill levels. They come from different abilities. Right? Some people are better than others. A new prosecutor may not be skilled in getting information from witnesses. They may not know what questions to ask. Over time, they may develop those skills. But some people may not have that particular ability. They may not do it very well, no matter how long they practice. Right? Those things are going to make differences in the outcome of the case. Different people have different ideologies. They believe that certain cases are more important than others. Some people may say that murder is not as serious as other offenses. Some may say that stealing ginseng is really important, and so we need to prosecute those particular cases. And so they're going to prioritize those particular cases. Some people may have difficulty reviewing a sexual assault case, whereas give them a murder and that's not as difficult. Different people have different perspectives on it. People also have different life experiences. So things that they've experienced when they were younger, as they were going through the school system, as they are out and about in the world, they experience things differently. And as a result, they are going to perceive things differently. They may understand a particular victim because of their past experiences. They may understand the defendant because of their past experiences. And as a result, they are going to take a different approach or a different way of looking at that particular case. In addition, different people simply have different ethics. Some people are okay with overcharging a case and saying that, yes, this is a good way, it helps me with getting leverage, negotiating a plea later. Others may say, look, overcharging a case is unfair. You're not charging the case for what it is. You are simply charging the case to gain an advantage, and you should not be doing that. Right? Different ethical perspectives on the same exact case. Now, the attorneys are also shaped by the offices in which they work. Each office has its own culture. Each office has its own way of doing things. And especially for attorneys who have never worked in any other office, they don't know any other way of doing things than how they were taught by those who came before them in the office. That has an effect on those who are making the decisions. If the office culture is we overcharge so that we get this negotiating leverage, even if the person thinks initially that this is unfair, in order to adapt and fit into the office culture, they may go along with that. Conversely, if the office culture is not to overcharge, but to charge what they can actually prove, that prosecutor's not even going to think about the idea of overcharging a particular case. In addition to that, that culture of the office may be reflected in office policies. They may have particular rules that are internal that say, unless you have so much marijuana, we're not prosecuting the case. Unless the person has stolen so much property that it rises to this particular value, we're not going to prosecute the case. Both of these things may influence the attorney who's looking at the case. They can decide to follow the policy. They may try to circumvent the policy as well. In addition to that, there are particular office structures. In particular, offices can set up horizontally, where the person who charges the case is not the same person who tries the case or who negotiates the case. Or they can structure the case vertically, where the same person prosecutes the case, negotiates the case, and tries the case if necessary. All of these different structures then provide either oversight in the case of what we call horizontal prosecution, where they pass it along, or it allows specialization in the case of vertical prosecution, where the same person handles it the whole way through. Attorneys who are specialized in a particular area get to know all of the issues inside and out and may make different decisions than someone who's not as familiar with those types of cases. Whereas in horizontal prosecution, you may have attorneys who are trying to circumvent office policy. That's going to get picked up as the case moves from attorney to attorney throughout the office. Beyond the office is the courthouse itself. The courthouse has its own particular culture, and there is what's called the courtroom work group, where the prosecutor, the defense attorney, and the judge, they all see each other all the time, and they all have to learn to work together, and they develop shared understandings about what a particular case is worth and sort of what a normal type of crime is. When they do that, then the charge itself actually becomes a means of communication. If the typical stealing case has over $1,000 and it's one count, that may tell judges and defense attorneys one thing, whereas if the prosecutor decides to charge a stealing case with 30 different counts, that may communicate something very different to the judge and the defense attorney, where they understand that this case is outside of the norm. Different court systems also have different sizes. Right? The prosecutor's office in New York City or Chicago or Los Angeles is not the same size as the prosecutor's office in Guilford County, North Carolina, or in Franklin County, Missouri. Those relationships in the bigger jurisdictions aren't usually as strong as those in the smaller jurisdictions where everybody knows each other. And so in those smaller jurisdictions especially, judges and defense attorneys may be able to exert a lot more influence than in these larger jurisdictions where there are so many different people. Finally, we have the community itself. The community has its own culture and its own understanding about what should be criminal and what shouldn't. You may have a particular jurisdiction that says, look, marijuana is okay. Even though the state says it is illegal in our county, we have a consensus that we don't really care if people are smoking marijuana, so therefore police, prosecutors, you should not be arresting and prosecuting people who are doing that. That's going to influence the prosecutor, because they know even if they do prosecute such a case, if it goes to a jury, the jury's likely to find the person not guilty. Jurors also have certain expectations for particular types of crimes, and so prosecutors need to understand how the community perceives those particular types of crimes. Different localities also have particular individuals who are influential. So the county commissioners or the mayor of a large city may have particular influence in certain cases. Political leaders may have influence. There may be significant businesses within the jurisdiction that have particular influence or particular concerns in a case. Those businesses, those organizations, those government officials are going to be able to exert some influence over the prosecutor's decision. So hopefully by this point you can see that there are lots of different things that are going to influence the prosecutor, and the prosecutor has tremendous discretion. And so we have to ask the question, how did we get here? How did we get to the point that prosecutors have so much authority and so much discretion in all of these cases? And the answer to that is found in the evolution of the prosecutor in the United States. The American prosecutor is actually unique in the world in terms of possessing all of this authority and all of this discretion. And so we have to look back in time to see how the prosecutor's role evolved. The lens that we use to look at this evolution is a concept that we call domain. It is basically the sphere of authority that a prosecutor has, or anyone has, in any particular organizational system. the prosecutor works within the criminal justice system, within the criminal court system, and over time they have expanded that domain so they have more and more influence over more and more parts of both the criminal justice system and the criminal court system. And also, you have to note that distinction between criminal justice system and criminal court system is really important, because in episode 3 we talked about the criminal court system, but the criminal justice system is actually much larger than just the court system, and prosecutors have expanded their domain outside the court system to encompass the criminal justice system as well. There are essentially 6 different phases within this criminal justice system as I'm going to identify them. The first is the legislative phase. Right? In order for us to have criminal violations, we must have criminal law. We can't just simply say, we're going to prosecute you because we don't like that you wrote this particular book. That's not a crime. There must be a legislative enactment that says writing this is a crime. Without that, prosecutors cannot proceed. Once we have a legislative enactment, we can move then to investigations. There is an investigation phase where we have to investigate and look for violations of that particular criminal statute. Once we have investigated, then we must initiate the charges, and that's what we've been talking about quite a bit already, is that charging decision. Once we do that, we enter into the negotiation phase, where prosecutors and defense attorneys are going to negotiate what the potential outcome may be. If they can't reach an outcome, or once they get into court, there is the adjudication phase, where we have to say whether the person is guilty or not. And then finally we have the correction phase. What's going to happen to the person after they are found guilty? We're going to see that prosecutors have influence over all 6 of these stages in the criminal justice process. First, in the legislative stage, they have the power to draft their own criminal laws. They have the ability to go to the legislature and lobby for those laws, and they are often called in to testify before legislatures about law enforcement concerns, about conduct that is occurring that is not already criminal, and they can advocate for particular types of statutes in order to criminalize certain types of behavior. They are recognized as the criminal justice legal experts, and so legislators are going to turn to them for advice and assistance. When it comes to investigation, prosecutors are going to work closely with law enforcement. Law enforcement wants their cases to be investigated thoroughly, to identify the guilty person, and to have that person prosecuted. So it's in law enforcement's interest to work with the prosecutors to give prosecutors the cases that prosecutors are willing to prosecute, to make sure the evidence is constitutionally collected and also is sufficient. And so prosecutors are going to provide some oversight, they're going to provide some guidance, they're going to provide direction in the investigation process itself. That way, when it gets to the third step, the initiation step, prosecutors are already familiar with the case, they've already worked through the case, they already know the evidence is sufficient, and so it makes that charging decision much more easy to decide. It also allows prosecutors to establish relationships with the officers when they work in the investigation process. They build up trust with the officers and can determine which officers are more credible than others. When it gets to the charging decision, as we talked about, prosecutors have near absolute authority to decide whom they're going to prosecute, for what, and when. So this is where the center of their authority lies. Now, one of those possible restraints is the next phase, negotiation. Right? Prosecutors just can't prosecute anything they want to. They want to make sure they have good cases to prosecute. because they know during the negotiation stage, defense attorneys are going to push back and try to get a lesser sentence for their client. And so in this negotiation phase, prosecutors, as we've talked about, already have some leverage. They can overcharge, they can impose the trial tax, and oftentimes when they decide on the charge, that charge then sets the framework for the negotiation. Defense attorneys who perceive the case one way may not be able to argue the case that way because the prosecutor didn't charge that particular offense, or they charged a different offense, or the prosecutors perceive the case a little differently. So prosecutors are able to sort of set the bounds for negotiation by using their charging authority. When it comes to adjudication, most cases don't get tried. They are simply resolved through a guilty plea. As we said, prosecutors have different means to persuade defendants to plead guilty. But if they do go to trial, prosecutors are often seen as, quote, the good guys in the courtroom. They're the ones who are trying to put someone away and protect the community, not trying to get a guilty person off. Now, again, embedded in all of that is this idea of a presumption of guilt, right? Juries are going to walk into a courtroom and they're going to say, I wonder what that person did, right? There is a presumption of guilt, that operating force within the criminal court system, and prosecutors have been able to take advantage of that during trial. Now, in all of these different phases, prosecutors probably have least control over the corrections phase. They can work with probation officers, they can work with parole officers, they can appear before the parole board. Once the case gets into the correction system, prosecutors do not have a lot of control over it. But one thing that prosecutors are now starting to do is create conviction integrity units, where they will go back and look at cases to determine if the person is actually guilty or not. There may have been a procedural error, there may be evidence collection errors, there may be mistaken identity, there may be newly found DNA or a newly found scientific test that exonerates the person. And so prosecutors are actually beginning to get people out of prison through these conviction integrity units, and we're seeing prosecutors again expanding that domain even further. So how did prosecutors get so much control over these 6 stages in the criminal justice process? They began as a rather minor, inconsequential figure in a much larger system. 250 years ago, when a person committed a crime, it was the responsibility of the victim of that crime to initiate the case. The victim might go to the local justice of the peace and complain. The victim may go to the justice of the peace and say, Joe stole my cow. I want Joe prosecuted. The justice of the peace would send somebody to go collect Joe, bring Joe into the office, and the justice of the peace may hear both sides, and if it's a small enough matter, simply resolve the case right there. If it was more serious, stealing a cow could be pretty serious, the justice of the peace will say, well, the victim has pretty good evidence that Joe stole the cow. I'm going to send this on to a group of people from the community who are now going to decide if the case should continue on to trial. That group of people was known as the grand jury. And so those people would, again, listen to so those people would listen to the victim. The victim would explain how the victim knows that Joe stole the victim's cow, and the grand jury would say, yes, there is enough evidence here for the case to go to trial. Only here would an attorney actually step into the process who is known as the lawyer for the state. That person's job was basically to write up the charges in a legal form, collect any evidence that was available, put it into a file, and then turn that file over to the court and have it in court for the next proceeding. When the court met again, that particular case would be on the docket. Joe would be brought into court. Joe could either represent himself or he could choose from any of the attorneys who were hanging around the courthouse wanting to present that case, if Joe could afford the person. Similarly, the victim is going to be talking to those very same attorneys and maybe hiring one of those attorneys to present the victim's case to the court. If the victim couldn't afford someone, the victim might turn to the public attorney who drafted the legal document, and that attorney might step in and present the case. In fact, it wasn't unheard of for this public attorney to represent both the prosecution and the defense in the same case. It was simply a matter of presenting the evidence to the court and allowing the court to decide. Over time, we found that this system was not terribly efficient, especially when it came to things such as morals offenses. So if you had public drunkenness, vandalism, if you had adultery going on, victims were not going to come forward and prosecute those types of cases. And so the colonial governments, the early state governments decided they needed a public official who was going to prosecute those particular cases. Eventually, that official in the early 1800s becomes an elected official. It is not someone who is appointed by the legislature or the governor or even the court. It is somebody who the citizens of a particular community are going to elect. That makes this particular prosecutor beholden to the electoral system, and especially in the early days, beholden to a particular political party. And as a result, prosecutors began expanding their discretion in the interests of serving their particular political party. This meant not prosecuting people who were part of the party, or it may be prosecuting people who oppose the party. It may be giving better deals to people who are political associates, not giving deals to people who are not political associates. Over time, prosecutors expand this authority then into the investigation process. Prosecutors become independent in some ways of political parties and are able to work with the police to actually put together cases based on solid evidence. Evidence that was collected in a certain way. They've become professionalized. At the same time, they begin expanding their domain into this investigative world. They begin gaining leverage over negotiations. Because the evidence is so strong through investigations, there aren't many cases that are worth going to trial over. It's better for defendants to plead guilty. And so now you see prosecutors going from this small little figure who is charging or who is responsible for drafting paperwork through creating charging discretion, through moving into investigation, negotiation, avoiding a lot of adjudication, and now moving into the legislative sphere where they are writing laws, or into the correction sphere where they are reviewing convictions that may have been wrongfully obtained. Finally, prosecutors realized that they could use their discretion to become, as one person has said, social engineers, where they are able to essentially work on and address social problems through the use of their discretion. So if a particular jurisdiction has a drug problem, prosecutors are going to be involved in dealing with that particular situation in ways that may have nothing to do with criminal prosecution. They may actually get to the stage where they say, if we have to prosecute this person, we failed in our job. They're trying to find diversion programs, so they may, rather than prosecute the case, put the person into some sort of drug treatment center where that person can get the help that they need. In addition, they're trying to solve problems that are caused by the criminal court system. The rise of incarceration and the move towards mass incarceration has caused parallel damage to families, to family structures, especially those families where people have been incarcerated. And that simply magnifies the crime problem. So prosecutors are now taking steps to reduce mass incarceration. They're finding ways to work within the system to actually incarcerate fewer people rather than incarcerate more people. And again, this is ways that prosecutors are expanding their domain as the system, as they gain more authority. So with that, we have now set up our last two episodes. We're going to look at the relationship between politics and prosecution. You can see there's lots of power floating around in this discretionary authority. There are lots of different ways to use it. There's lots of different influences on that discretion that prosecutors possess. And so now we have to look and see the different ways that politics influence prosecutors and that prosecutors influence politics. So for that, thank you for watching. We ask that you would subscribe to this channel if you want to see more episodes. You can also find us in the podcast world. We have the Politics of Prosecution Podcast. It's on Spotify and iTunes. Soon we're going to have a video series about case studies on politics of prosecution. We also have an Instagram account at poli.n.pros, and we are also on Twitter at poli.pros. Thank you again for watching, and we look forward to seeing you for our next episode.